Good evening to everybody, my friends. Yesterday, I discussed on a topic regarding service matters of government employees. Today, I am going to discuss on a topic which is a burning issue nowadays, especially I felt it when I used to deal with such matter in my court while discharging my duty as a judge. The topics is on bigamy. Bigamy is a criminal offense of marrying someone committed by a spouse while he or she has a living spouse from whom no valid divorce has been obtained. Bigamy is an offense which is provided under section 494 of Indian Penal Code 1860. Punishment for such offense has been enunciated under section 494 of Indian Penal Code for a punishment of 7 years imprisonment or fine. Now, when such an offense of bigamy occurs or happens, I will discuss such offense of bigamy under Hindu Marriage Act 1955. Section 5 of Hindu Marriage Act 1955, Clause Roman 1 provides that a spouse cannot contract a second marriage while another spouse is living. If a spouse contracts a second marriage while another spouse is living, then such marriage is declared to be void under section 11 of the Hindu Marriage Act 1955. During the course of my official duty, I became very much fed up and or frustrated while dealing with such kind of matters because the loopholes as provided under the provision of section 11 of Hindu Marriage Act are that The plaintiff who files the application under Section 11 of Hindu Marriage Act 1955 before the district court or the family court having jurisdiction to try this suit has to prove that the second marriage is valid. I can't understand till now as to why and how the plaintiff, the victim husband or victim wife can prove the second marriage is valid. It is very much difficult to prove because we know in order to make a marriage valid under Hindu Marriage Act, the plaintiff has to prove that either the marriage was solemnized as per customary ceremonies or rites, or the marriage was solemnized following the procedure of Saptapadi as provided under Section 7 of Hindu Marriage Act 1955. I can't understand how it is possible to the plaintiff to prove such criteria. So, through my YouTube channel, I would request the Parliament, that is the legislature, to amend the provision of Section 11 of Hindu Marriage Act 1955 or Section 494 of Indian Penal Code 1860, so that the burden of proof must be shifted upon the accused to prove and establish that he or she didn't make a contract of second marriage. In our adversary system, I know in view of Section 101 of Indian Evidence Act 1872, the plaintiff has to prove his own case. But the special act like POXO Act, it is just the reverse. The accused has to prove that he has not committed such an offence. Either it may be under Section 4 or Section 6 of the POXO Act. So, I would like to draw the kind attention of the legislature to immediately amend the provision of Section 11 of Hindu Marriage Act 1955 together with Section 494 of Indian Penal Code. Otherwise, the victim persons, whatever be it the husband or the wife, would be suffering much, and he or she would be highly prejudiced. During the tenure of my serving judge, I couldn't give any sentence of punishment to such erring husband and wife who contracted second marriage. So I repeat and reiterate that legislature should give importance to such crucial point which is a burning issue too in the present days. Just now I am ending my program, and I think the learned advocates and other persons who are affected thereby would also cooperate with me on this issue and forward this issue in a widespread. Thank you very much. Hello.